Good morning, and I'd say thank you for the invitation, but I really didn't get an invitation for this talk. I kind of weaseled my way into it. To tell you a little quick story about how it all happened, I did a presentation on ethics, and this is basically the same presentation for a national CE group out of Wisconsin called National Business Institute. And I've been instructing for them for years and years and years. And did this ethics presentation, and then I knew every year at this meeting there was an ethics presentation, but the gentleman that usually does it in the past year changed jobs and would not likely be here this year. So after I did my presentation on ethics in February, I called Melissa and said, hey, if you need a replacement for George, I said, I can do it. You know, we just have to kind of translate this from Texas ethics to Arkansas ethics. And she said, great. So I told her the topic was a common sense approach. And so the very first bulletin that you got on this, it gets sent out and it says, here's the bulletin, here's the agenda for the meeting. And I look and there's my topic, a common sense approach, but the picture next to it, it wasn't me. Okay? I went, son of a gun, Melissa replaced me. She got somebody else to do my topic. My boss calls me and says, Ron, I thought you were speaking in Arkansas. I said, so did I. Ring, ring. Melissa, what happened? Well, she says, I didn't have your picture from the previous years, so I went out on Google and I looked. AI, right? I went out on Google and looked, and if you Google my name, there's like 5 or 6 pictures. So she picked one. I can send you one, Melissa. So the one that you have is correct, although the guy that was on the original, probably better looking than me, so anyway. But that's how this all came about. And really when you come down to ethics, in my opinion, ethics really is a common sense topic. It's very difficult to write a paper or do a presentation on it, but really, not really. It's very commonsensical, should be commonsensical, shouldn't matter what state you're in. It's the way we should be doing business. And so that's the way I'm going to approach this morning. We're going to talk about a couple of rules, and then I'll explain. There is a case in here. It is a Texas case. And I have to give this caveat. I am not an Arkansas attorney. I'm not licensed in Arkansas. But as close proximity as we are, there are court cases that I see when I read Texas opinions, they relied on an Arkansas case because we didn't have any precedent. And likewise, I'm worried that this could come up here in Arkansas. I just want you to know about just the concept and just the principle, because it really is kind of a strange case. So with that, let's get started. I start my presentations with objectives. Here's what we're going to accomplish. We're going to look at the rules of professional conduct for the attorneys in the room. This is the case I'm talking about. It's Home Loan Corp versus Texas American Title. Lawyers and title insurance companies. We'll talk about the use of trust accounts, representation of multiple clients, conflicts of interest, and disclosures of defects in properties. Those are the kind of things that I want to talk about. Start with a definition. This is Webster's, a consensus of expert opinion as to the necessity of professional standards. Black's Law Dictionary. How many still have a Black's Law Dictionary? All you lawyers. Yep. Sits on a shelf in my office, and the first thing I do when there's a term I don't understand, do I go to Black's? No, I Google it, right? No, I still use Black's. Black's says ethics is usages and customs among members of the legal profession involving their moral and professional duties toward one another, toward clients, towards the courts, that branch of moral science that which treats of the duties which a member of the legal profession owes to the public, to the courts, and to his professional brethren, and to his client. So that's what we're talking about. Now, Arkansas, as I understand it, and this is all Westlaw researched, and because again, I'm not an Arkansas attorney, but it looks like Arkansas adopted the ABA model rules of professional conduct somewhere in the 80s, but there are some differences. The preamble to the rules, which I think are very, very important. A lawyer is a representative of clients, an officer of the legal system, and a public citizen having special responsibility for the quality of justice. Look at the roles that they identify next. As an advisor, a lawyer provides a client with an informed understanding of the client's legal rights and obligations and explains their practical implications. You also serve as an advocate. A lawyer zealously asserts the client's position under the rules of the adversary position. You serve as a negotiator. A lawyer seeks a result advantageous to the client but consistent with requirements of honest dealing with others. You serve as an evaluator. A lawyer acts by examining a client's legal affairs and reporting about them to the client or to others. In addition to these representational functions, a lawyer may serve as a third-party neutral, non-representational role, helping the parties to resolve a dispute or other matter. But a non-representational role, a third-party neutral, what is that but an escrow officer or a closing agent? So we have all these functions as lawyers, but then it also involves all the other people in this room, the escrow officers, because you are an independent third party. How many people have heard, yeah, we're independent third party, we're in the middle, we don't, right? But with that comes certain duties and responsibilities to everybody involved. Going back to our attorneys, we learn you only undertake matters for which the attorney is competent of handling. If you agree to handle it, do it, and do it diligently. Communicate with your client and customer and keep them informed. Charge a fair and reasonable fee. Maintain the client's confidentiality. Make full disclosure of any potential conflicts. Keep safe and separate the client's property and decline representation when appropriate. That's ethics. I don't care what state of the union you are in. That's ethical behavior. The very first law firm I worked for, the attorney, great mentor for me in the area of real estate, but he was also on the Houston Bar Association grievance committee. And he told me, he said, the best way to avoid ethical problems, you not only avoid violating ethical rules, you avoid violating or appearing to violate ethical rules. Don't give them a chance to say that you're doing something that's not right. We'll go back and I want to hit some of these individually and we'll talk a little bit about them. And first we're going to talk about the lawyers in the room, about their ethics, and then we'll extend this to other title professionals. We all have a state bar license. We're licensed as an attorney and counselor at law. My license does not say I'm licensed as an attorney and counselor at law to do only real estate matters. It says I can do anything I want to do, right? So we got rules. As you heard, I did 2 degrees in engineering. Now, dummy me, there's a lot easier ways to get into law school than doing engineering, right? Because you all got to have a college degree. Sociology, one of my buddies was a psychology major or something. A lot easier to get into law school with an undergraduate degree and something like that. I did 2 degrees, 6 years of engineering school, threw it in the trash, went to law school, right? But even in engineering, my degrees are in industrial engineering. There's mechanical engineering. There's electrical engineering. There's chemical engineering. And as an engineer, when I was working as an engineer, I wouldn't attempt to do some of those others. I knew what I knew in the topic that I knew, and that's where we are under the law. There's no restrictions on a subject matter, so only handle topics that you know about. Or if you're going to handle a topic that is not in your area of expertise, you better associate somebody with you that does. If you agree to handle a topic or a matter for a client, do it, and do it diligently. Don't keep putting it off. You know, you want to make sure that you take care of them and take care of them properly. Like I said, and if you really get to the point you can't associate somebody with you if it's not your area of expertise, don't do it. Someone comes to you and wants you to handle a matter and it's not your area, you don't have to take it. Decline it. It's not me. Maybe I can help refer you to somebody who can help you better, but that's not me. In the area of communication, you know, it's communication, communication, communication. Return phone calls, emails, texts, even in the title industry, before I got into title. I started in title, this sounds strange. I started in title at the turn of the century, right? No, it was December of 1999 is when I got into title. I was working for Shell Oil Company at the time, buying, selling, leasing gasoline service stations and C-stores, occasionally transferring title to refineries and storage facilities and things like that, right? And they called me and said, do you want to be a title underwriter? Sure. I didn't know what a title underwriter was. I got to my desk and I said, okay, I'm here, what do I do? But I had an escrow officer. It was the title company that did my insurance for me for Shell. And I would call them and say, I've got a question about this particular place or service station that I'm going to close. They would never answer the phone. It would go to voicemail. And then I would get a return phone call at 6:30 at night. Hi, trying to return your phone call. Sorry I missed you. Well, who's going to be at their office at 6:30 at night, right? Sorry I missed your call. And they would call back. And then you'd play phone tag like this for 3 or 4 days. That's not taking care of your customer. That's not taking care of your client. Return your phone calls. Now you've got emails. Now you've got texts. As I was sitting here this morning, and I'm up in my room last night and this morning before we started, got my laptop, got Wi-Fi connection. I'm responding to emails because I've got 5 or 10 minutes. Keep current on your communication. Make yourself available to discuss the merits of your file. Don't be one that wants to call only when you have good news. Hey, we got this resolved. Sometimes we as title professionals, as underwriters, we can't get there. Somebody asks us for something and we're not able to do it. You got to share the bad news along with the good. Do not withhold information. As soon as you get information, let them know. Now that probably looks like most everybody's desk, or at least it's mine. You know, I'm still kind of paper intensive. As Michael was reporting in his previous, you know, I'm one of those old guys that's, you know, I've got a brother-in-law that still has a flip cell phone, okay? And then when he texts, you remember, you didn't have letters. You had ABC was on the 1 and you had to push 1 3 times to get a C, right? So I can't text him because it takes him 3.5 hours to text me back. But yeah, that looks like my desk. I have notes and things, and we've evolved from that. Hopefully we've evolved from that. On the topic of attorney's fees. Now this gets to be a very critical topic for title insurance, and you'll see why in a second. Okay. A lawyer's fee shall be reasonable. A lawyer shall not enter into an arrangement for charge or collect an unreasonable fee or unreasonable amount for expenses. Anywhere you go, that's the rule. Don't overcharge. You get to consider the time and labor involved, the difficulty of the question, if acceptance of the matter will preclude acceptance of other work, time limitations given to complete the task, and the level of experience, reputation, and ability of the attorney performing the services. Obviously, when I was an associate right out of law school, I didn't charge the same rate as the senior partner. He'd been doing it for a lot longer than me. He's charging $300, $400, $500 an hour. I was charging $150, $250, something like that when I was doing my private practice. So your experience, the level of knowledge, all of that comes into play. Understand when we get into title insurance, you're likely going to see a different fee structure for something like a sale of a single-family residence versus a complex multi-site commercial transaction. When I was closing with my prior, and it was First American I worked for in the National Commercial Office in Houston, I'd sometimes get bills for lawyers representing lenders or buyers, and they would be in the tens of thousands. I think the biggest one I got was pretty close to $100,000 that we put on a settlement statement. But it was a several $100 million transaction, okay? Now, you're not going to be able to charge anything like that. May only be a couple of $100, but keep your fees reasonable in context to what the service is. Now, I got to ask this question, and this is just out of curiosity. It's not even scripted. It's off script. How many of you have ever gotten a title objection letter on a residential transaction? Have you? Yes, I did. Somebody, a lawyer buying a condominium, yes, in downtown Houston. And I got a 6-page title objection letter on a residential transaction. Are you kidding me? Now, I'm used to getting those on, you know, the big ones, right? The $100 million ones, the $150 million transactions, but not typically on a residential transaction. Understand that the rule about attorney's fees is intended to create a ceiling, not a floor. This is what the most you can charge. But this is where it becomes to the advantage in the title industry, because a lot of times, okay, you can charge whatever you want as long as it's not excessive. If you want to represent a client on a real estate transaction and charge nothing, you can do that. There's nothing in the rules that says that you have to charge. And this is where we get into it in the title industry, because in Arkansas has something that is really, I will say, unique, foreign to me. Of course, most of you think that Texas is a foreign country anyway, but it's foreign to me, and that is the split closing table. That rarely, if ever, happens in Texas that I've ever exhibited. And I was asking my compadre yesterday, and I said, what happens with when you're doing, and I get questions, we got the loan side, or we got the buyer's side, or whatever the case may be. I said, what happens to your simultaneous issue rate? Goes out the window, right? So this client's now paying twice for the same territory. But this is where you can sometimes get around that. Because if it's an attorney office that's closing it, then they can reduce their attorney's fees by or maybe that incremental amount in the differences, and there's nothing that says that you can't do that. The rule on attorney's fees, reasonable attorney's fees, is a ceiling, not a floor. We have a lot of attorney fee offices. We'll get big developers. They'll get an attorney that sets up a fee office with a company so that they can go in there. And as you know, Texas rates are probably, not probably, I will tell you, Texas rates are much, much higher than they are in Arkansas. Okay? I mean, we have and start at our lowest tiers at probably over somewhere around $5.50 or close to $6 a thousand for the lower tiers, right? So this is how they get around it. And they set up and they associate with an attorney and they say, look, you're going to do a bunch of my business. You do the attorney's fees, and then you've got to collect the premium, but then you can reduce my legal bill by that amount. There's nothing that says that you can't do that. That's all okay. When you do a title objection letter, make reasonable comments. Make sure your comments are legitimate. This is no lie, I actually had on a transaction, a lawyer complained to me that they didn't like the font in my commitment. Could I change it? It was like Arial font. Could we change it to Times New Roman? And for this, he's billing his client $300 an hour or something. Come on. Let's be sensible. Here's the big question, and this is where it goes now to everybody in this room, whether you are a lawyer or whether you are a escrow officer, if you are a title officer, whatever. The question that we have is, are you a fiduciary? You know, we all want to reduce liabilities and things like that. Fiduciary is from the Latin fiducia, meaning trust. A person or a business like a bank or a stockbroker who has the power and obligation to act for another, often called the beneficiary, under circumstances which require total trust, good faith, and honesty. A fiduciary relationship encompasses the idea of faith and confidence and is generally established only when the confidence given by one person is accepted by the other. The duties of a fiduciary include loyalty and reasonable care of the assets within their custody. This is where that Texas case, and again, recognizing this is not law here, but recognize the concept and what Texas American Title got tattooed for. All right? So this case had to do with a loan that Home Loan made and disclosure or lack thereof on how the loan proceeds were to be distributed. So they did a closing settlement, and I'll try to condense this as much as I can. They did a closing or a settlement statement, and Home Loan showed, well, let me back up. The problem arose, Home Loan sold the loan on the secondary market, and then the loan went into default. Nobody ever made any payments on the loan. Loan went into default, and Home Loan had to buy it back. And then when they found out the reason why nobody made any payments, that's when they started going after, they went after the title company. Okay? The escrow officer did a settlement statement showing that the proceeds of the sale back to the seller was X. I remember somewhere $74,000. Right before closing, the escrow officer got instructions, okay, to disperse from the seller, to disperse those funds, 50% of it, to the loan brokerage, to the loan broker. And when that was rejected, it was revised and said, okay, don't send it to the loan broker, send 50% of the proceeds to the principal of the loan broker. This was never disclosed to anyone. They did their instructions. They did it. The loan went into default. Home Loan went back and said, look, you didn't tell us this. You didn't disclose where the money was going accurately on the settlement statement. And your failure to disclose, had we known about this, we might have decided not to make the loan. This was important information for us to know. Why is this loan broker getting 50% of the proceeds of the sale. Something is not right here. Had we known this, we might not have made the loan, and thus the loan would not have gone into default, et cetera, et cetera, et cetera. Basically, I kind of thought here what they were doing is going to the deep pockets. I kind of look at this in question and say, if that seller gets the proceeds, they can do whatever they want with them. If they want to give them to charity or whatever. But some of this, the lender was able to convince the court and say, had we known that, we might not have made the loan. And we deserve to know where this money was going. And so it went up on appeal. Originally at the trial court, the title company won. And on appeal, the appellate court not only reversed, they reversed and remanded and said, look, if you have information that might be important to someone in doing the transaction, you, as a fiduciary, have that duty to disclose. Now again, all right, the older lawyers in the room, I was about to use a term. I shepherdized this case, which was, remember that little book that you looked up and, you found a case and what other cases cited it? Now you do it on Westlaw. But I checked. There's no Arkansas court case that follows this. But what I am concerned about is when a court jurisdiction does not have any kind of precedent, the first thing they do is they start looking at states around them, right? Who else has decided something on this? What rationale did you use? And that's why I present this. I thought about taking this case out, but I said, no, this is important to know because just the concept and the process. If you have information, you are probably deemed to be a fiduciary. You owe a duty and a responsibility to the buyer and the seller and the lender in a case. And you have a responsibility, if you have information, to disclose it. Court said a fiduciary duty of full disclosure requires disclosure of all material facts known to the fiduciary that might affect the rights of the person to whom the duty is owed. That's all great. Material facts. What is a material fact? Okay? What is a material fact? You go back and look at it and say it encompasses the idea of good faith and a duty of and a responsibility. But again, leads you to a couple of questions. How do we, as a title company, how do we know what information, if disclosed, would be or would be considered to be pertinent in the decision-making process? And then we have, as part of our professional rules of conduct, that we have to maintain confidences. And now you've got this budding, well, it may be important for the lender to know this, or the seller to know this, or the buyer to know this, but you could be revealing or disclosing confidential information. So it really can be a dilemma. I'm not here to tell you that I have the black-white answer on this. There's just a lot of gray in a lot of this stuff. In title insurance, lawyers wear many hats. Okay, they can represent the buyer, the seller, the lender, the title company. Like I said, here in Arkansas, you've got split closing tables. There's all kinds of stuff that can be going on here. And there can be different rules. We as lawyers, we have the rules of professional conduct that we have to follow. Arkansas Insurance may have some rules about how escrow officers, or if you're serving in that capacity, or a title officer or something, how you behave. As a general rule, now I'm talking about, I work for Westcor, so what we do is if you're in there and you're representing a buyer or a seller, and Westcor is going to be you're also the title company and you're insuring on Westcor paper, then we kind of like to say, hey, we'd like to look over your shoulder on any underwriting decisions that you make to make sure. That just avoids the conflict of interest. Lawyers are supposed to have a trust account. An interest on lawyer's trust account, or IOLTA account, has to be a separate interest-bearing account. One of the first firms that I worked for, and this is about the time I decided I was going to leave, I found out from the accountant that he took monies in that he was holding for clients and deposited into his personal money market account. And so he was reaping the interest off of this. And I said, why, when this guy goes down, I'm not going down with him, so I'm getting out of here. But it's got to be separate. You maintain it separate. You can commingle client funds in that account, but you cannot commingle it with your own money, your own operations. That's why we in the title industry, you have an operations account, you have an escrow account. Money goes into that escrow account, but every file has its own independent GF number or file number. And then you maintain a checking account for that, and at the end of the day, when you finish that file, it better have a zero balance. And if AID is anything like the Texas Department of Insurance, they will come in, and when they audit you, they're going to be looking for those zero balances in all of those files. And if there's not, they're going to start asking questions why. On the topic of conflicts of interest, most misunderstood thing in the ethics world, people say, oh, they can't do that, it's a conflict of interest. Well, okay, define a conflict of interest means you could have competing interests with clients, different clients and stuff. But if you can show that you can do what you've got to do without violating any of the confidences, and typically with written agreement by all parties, you can take the matter, okay? You can take the matter. Go back to the example that I just used a minute ago. You're representing a buyer or a seller or a lender on a deal, and you're getting, as a title company, and you're getting a Westcor policy. Well, you disclose that to me and say, hey, there's no underwriting issues here of any significance. If there are, I'll bring them to your attention. We look at them, and I sign off on them. Hey, I'm good with that. It's a conflict of interest, but it's permissible. So conflicts of interest are not necessarily, just because of the fact they're a conflict, doesn't mean that you can't do them. You just have to, again, it's disclosure of the facts. What's the potential conflict? Get the agreement of everybody, get them to sign off. Now, this was something that was interesting that I had to research in Arkansas, because this is contrary to statutory law in Texas. There is not a statute that requires a seller in Arkansas that I could find, somebody correct me if I'm wrong, that requires disclosures of any defects on property. But, what I did find was the Arkansas Real Estate Commission has a regulation that says if you use a licensed Arkansas realtor to represent a buyer or a seller, then what's their acronym? Do you call them AREC? AREC, Arkansas Real Estate Commission, or whatever. They have a form, and they require, if you're going to use a realtor, okay, that there is a disclosure form that has to be filled out. That will disclose property conditions. But there's no state statute that requires. In Texas, we have a state statute, and it also prescribes the form that of what you have to disclose. It's a commission regulation, and they talk about licensees under the Real Estate Commission, that they'll use every effort they can make to get this information and disclose it. The question then gets me, what's reasonable efforts? And then what is your responsibility as a title agent to make sure that this is done, and that the other side, if it's the seller, that the seller completed the form and it got to the buyer, okay? Doesn't appear to be any requirement to make sure, but it's just regulatory. Reasonable effort doesn't mean that you're going to require an agent go into a house and tear off the sheetrock and look behind the walls to see the condition of the insulation, or whether or not there's termites or bug infestation or anything like that. But if you see a spot on the ceiling that's a water spot, you might start asking questions about what's the condition of the roof, how old is it, is there a known water leak, where is this spot coming from, okay? And then you could have some interesting discussions on what would be information that could cause a variation in the material value of the property. Go through the form real quick, but what I found from on the Arkansas Real Estate Commission, it has 12 basic sections. You talk about environmental issues. Is there any lead-based paint, septic underground problems, house systems, what's the condition of the plumbing or the electrical, the appliances, is there any problems, any structural defects, any known termite or insect damage, what's the age of the roof, are there leaks, is there any soil stability problems, is there a prior survey, where on that prior survey did it represent any boundary issues, any improvements added since the last survey, unrecorded easements or burial plots, does it have a water supply, is it adequate, where does the water supply come from, is it public, private sewer, or septic, any additions or remodeling since the last time that somebody disclosed, is there a homeowners or a property owners association, assessments, are there any common walls, like if it was a condominium or a townhouse, are there any shared walls, shared roofs, or anything like that? And finally, any miscellaneous or pending legal actions. Now, this last one's very, very important, because I had this just happen to me in a case where a seller was selling property, and it was a builder, and they had a dispute, and they actually filed lawsuit for defects in the construction with the builder, okay? And they signed an as-is current condition contract with the buyer, and they did not want to disclose that they had a lawsuit with the builder for construction. Well, we said, well, look, you can't, you're giving them the disclosure. Disclosure says you've got to reveal if there's any pending litigation on the property. Well, we don't want to do that. Well, if you don't want to do that, then we have to decline it. You're going to have to take it down the road to another title company, because you've signed a form here that says there is or there is not. Now, if they disclose it on the form and you give it to the buyer, and the buyer doesn't read it or whatever, we can't force them to read it. We can't force them to take it into account. We can't sit there with a highlighter and circle it and underline it in red and all that kind of good stuff. We don't have to do that kind of stuff. But you've got to make sure that some of these disclosures on property conditions and things, if they are mandated either by regulation, as they are here in Arkansas, or by statute, as they are in Texas, that those disclosures are being given. Now, this is another interesting topic that I researched. And I came across a map on this. It was an interactive map of all 50 states. And you clicked on the state, and it gave you the law on this topic. What do you do if you have knowledge about some sort of significant criminal event, or just a significant event that took place on the property? And I'm talking about a murder, a violent crime like rape, or suicide. Now, I don't know, you're looking around this room, if you're going to buy a house, I think everybody in this room would want to know, had something like that, had it happen, why? Does it tarnish the house? No, but some people might take that into account. And so there was this map, and you clicked on the state, okay, and it said what the law was in that state with regarding to these types of events. And surprisingly, and I started looking around, and of course, the region that I'm in is Texas and all the states that touch it. So New Mexico, Oklahoma, Arkansas, Louisiana. So I did Texas and all those other 4 states. And it was very interesting, but nobody, no state, has a statute requiring this. There is a statute in Arkansas dealing with the topic, but it does not require disclosure. Okay? It does not require disclosure. Saying that the value of a home could be compromised by the knowledge that this, that's not for us to determine. That's for the buyer to determine. Do you want to buy a house where one of these events occurred? Interestingly enough, the discussion, and I found some legal articles in Arkansas on this topic, and in addition to these topics, they included paranormal activity. And surprisingly enough, I don't know, do y'all have a big problem with this? Meth cookers. It specifically mentioned meth cookers. Now, maybe we have that problem in Texas, and I just don't know about it, but they talked about these topics: murder, rape, suicide, paranormal activity, and meth cookers. Well, did you want to know? I could see maybe in meth cookers because it might absorb into the walls, and it might, who knows? Okay? The Arkansas statute is here, and it talks about properties being psychologically impacted and a transferee, but it does go on, and it says there's no cause of action in subpart C. No cause of action shall arise against an appraiser, a licensee as agent of an owner, a licensee as agent of a potential actual transferee of property for failure to inquire about or ask about this. But I think the important thing here is the responsibility is there under the Real Estate Commission rules in any state that I looked at that says if you actually learn of an event, you don't have to go out and start digging in the ground and turning pages and things like that. But if you actually learn, seller comes to you as an agent, as a real estate agent, and says they're getting out of the house because their youngest son committed suicide on this property. When you have actual knowledge of that and it's given to you, you then have, if nothing else, a moral obligation to reveal that to the buyer. So we're getting to the end. And everybody likes this because the guy that speaks before lunch, would you shut the hell up and get off this? So we want to eat lunch. So I'm going to give you a few minutes back. So we'll go about this with summary, and I'm going to close. Ethics is not that complicated. It really is not. And it really is and involves a common sense approach. Treat other people like you would want to be treated. Take on matters within your area of expertise. Give it your best effort. Complete in a timely manner. Charge a fair price. Communicate. And if you have information that would affect the value of the deal or someone's decision to conclude a deal, consider disclosing it. Sometimes you can't because there are rules that say you can't, but you should at least consider disclosing all of that information. Keep any unearned funds, any fees separate in trust accounts until you've earned those fees and it's time to disperse. And all of this is intended to cap your liability, okay? To keep you from being held responsible monetarily for things that are not told and violating any of these rules. Now, when I did this presentation earlier, and I think I did it at a presentation in February of this year, and I was telling one of my other co-underwriters at Westcor, and I'm doing this, I wrestled with this, I don't want this to be controversial, but I don't think, being in the state of Arkansas, this is going to be controversial. But I want to close with this thought. Ethics, like I said, is how you treat other people, how you would want to be treated. And he suggested to me, he says, you can boil ethics down into 4 letters. Okay, and I want to close with those 4 letters. Isn't that it? Isn't that really it? And I don't mean to offend anybody if, making a religious reference here, but that's what ethics is all about. And you stop and think, at that point in time when you were a kid growing up and your mother told you, when you're considering doing something, and you get that hollow feeling or that in the pit of your stomach, maybe you shouldn't be doing that. That's what ethics is. Treat other people with respect. Treat them like you would hope they would treat you. And hopefully, if we can get everybody to do this, the world's going to be a better place. Thank you for the non-invitation. No, I appreciate the hell out of being here. I really do. I really, really do. Excited to be here and speak. I hope you got something out of this today. And if you have any questions, I'll be around. Feel free to ask me. Thank you very much.